Welcome everybody. My name is Paul Molina and I am the principal at the Molina law firm PLLC and I'm very happy to be with you. Thank you for coming. On this golden paper in front of you is our family wealth needs assessment evaluation, and what you're going to do today is you're going to fill this out, and after you filled it out you're going to bring it back to me and we're going to discuss your next steps if you feel like what we've shared today is beneficial to you. So this is an interactive presentation, meaning you're going to fill this assessment out as we go along. So please keep it by, and I'll give you some prompts to let you know when you can start filling it out based on the questions. This is only going to take about 30 minutes, so we'll have you in and out. But I do thank you for coming, so let's go ahead and get started. As I mentioned, my name is Paul Molina. I've been a practicing attorney for over 13 years now. I started in New York as a matrimonial attorney. I've done transactional law, and I have migrated over to estate planning because of a story a colleague shared with me about 4 years when I moved to Oak Cliff, and it involved a little girl. She was 2 years old at the time of the incident. She was in the back seat. Her parents were in the front seat, and they were hit by a 16-wheeler, and the parents did not survive. So what followed were years of trauma, family infighting, court conflict, all at tremendous expense, and all of which could have been avoided had the parents planned ahead of time. So what happens most of the time is that planning for the future is something that we procrastinate on because we don't need it in the moment. And that continues to go on until a life-changing event happens, and by the time that happens, it's too late to plan. Without tremendous cost, without tremendous time, without tremendous emotional expense. So what we do at the Molina firm is provide seminars like this, and we come out into the community and we provide educational opportunities so that you know that there is an opportunity to plan before it's too late. On a personal note, I'm also a dad. These are my wife and my 2 children, and these are who I plan for. They're the ones who are going to benefit from my planning. As we get started, why don't you look on your evaluation and share who the people are that will benefit from your planning, the things you will do today. Will it be your parents? Will it be your spouse? Will it be your kids? Maybe even a pet? Why don't you take a moment and write that down now? And while you're doing that, let's look briefly at what estate planning is exactly. Typically, estate planning refers to the creation of documents that accompany end-of-life and incapacity decisions, including powers of attorney, healthcare directives, wills, and trusts. But personally, I'm not a huge fan of the term estate planning or even the regular process of it, because generally when that term is used, estate planning focuses on the production of legal documents, but it leaves out the whole part of what makes these documents work. Leads to big messes, leads to failed plans, leads to loved ones who are lost, confused, and need grief when something happens. They don't know where to turn. They don't know who to talk to. They don't know where your assets are. And all the while, they're searching for all these things as they're grieving. So what we at the Molina firm like to do is called life and legacy planning. And while it does include wills, trusts, healthcare directives, powers of attorneys, it is more than that. What we do is a proactive plan that supports you to make informed decisions, to create documents, to create systems in place that leave your loved ones with legal and financial clarity. We provide a trusted advisor and the documents and guidance necessary. So if you become incapacitated or when you die, your loved ones know what to do, what you have, how to find what you have, and who to turn to so they aren't confused while they're grieving. On top of that, when done well, life and legacy planning supports you to have more financial and legal clarity during your lifetime and results in you having your best life and creating a legacy worth leaving. So, as I mentioned before, life and legacy planning is something that you do for yourself and your loved ones. But it is not just for those who have a lot of money in the bank. So let's take a look at what happens when you become incapacitated or when you die so you can clarify who you are planning for. If you become incapacitated and cannot manage your legal or financial affairs or make healthcare decisions for yourself, someone will need to step forward and make those decisions on your behalf. On your golden assessment, write down right now who would make those plans on your behalf in the event you couldn't do it for yourself. And I'm not referring to who you would want to make those plans, but practically speaking today, who would be in the position to make those plans. Now note if that's the person who you want to step forward. If you're married, perhaps it's your spouse. Well, what if something happens to both of you together? Who makes the plans then? And again, is that the person you would want? Note that down now. If it is the person you would want, great. But would they know how to find your assets? Would they know who to turn to and what to do? If not, note that down on your assessment, that I need a plan for the people that I love. And do you have a business? If so, would the people counting on you know what to do and how to keep the business going without you? If not, note that down now. So the first thing we can see about life and legacy planning is that someone will have to make sure your affairs are handled after you die or if you become incapacitated. By making those decisions and plans now, you're relieving a huge burden for them and saving them a potentially expensive, lengthy mess to deal with. So, as you can see, life and legacy planning is first and foremost a roadmap for the people you love once you're gone. But life and legacy planning is not just for them, it's for you too. What we hear repeatedly about our process at the Molina firm is that planning brings a clarity, relief, and depth, and even a dignity around legal and financial decision making that people have never felt before. It leads them to feeling more responsible, making better decisions as a parent, either for themselves or for their children, better decisions as a member of the community, and to making better financial decisions when it comes to their relationship with money and work. And yes, that means having a plan for if you become incapacitated and can't take care of yourself. You already wrote down in your worksheet who would care for you if you could not care for yourself, but would they know what you want? Would they know how to make decisions for you? Would they know how to find your assets? Would they know how to pay your rent or your mortgage? Would they know how to communicate with your doctors or even who your doctors are? Now, I do know that, and I understand that it seems unlikely to happen, but if it does, the consequences are significant, and they can lead to you not being cared for in the way that you would want. We see it all too often, that when someone becomes incapacitated or dies, their friends and family call, they're lost, they're confused, they're grieving, but by then, it's too late to help them with anything without significant investment in time and money. So before we move on and look at the plan that's already in place for you, which is the state's plan, what would happen to your friends and family if they called us after something happened to you without any planning in advance, let me know in the worksheet if you had to choose one, yourself, your family, your friends, or your business, who would you be planning for? And as you're doing that, let's look at the plan that you do have in place because the state has a plan for you. First, all of your accounts are frozen. If you're in the hospital, somehow your rent or your mortgage still need to be paid. If you die, someone will have to pay your funeral expenses if you haven't already made those plans before your death. If your family cannot find or get access to your assets, you could lose your lease or even your house, and that's usually the biggest asset for people. A colleague shared that a daughter inherited her father's house, but she couldn't pay both her mortgage and her dad's at the same time, so she ended up losing the father's house to the bank and all of the equity the father had put into that, which is, I'm sure, not something the father would have wanted. So I only raised that to bring out that planning really does need to be done, and assets do need to be secure before you pass, because the people who you want to benefit from your largesse may not be in a position to financially afford that benefit if they are stuck between paying their homes, taking care of their own bills, and then also paying on a house that they inherit. So in any case, there are many steps forward in the probate process, and there are delays intentionally built in along the way. Fees are speculative, but the the general rule of thumb is that all of the probate fees are going to cost about 2.5% of your total assets. And that doesn't include court filing fees, it doesn't include attorney's fees, which can be significant. It doesn't include bond premiums, it doesn't include appraisal fees, among others. Additionally, it also routinely takes around 6 months in Dallas for you to even allow your family to have access to those assets. And if you have kids, a judge who you do not know, a judge who your children do not know, will decide who raises your children without your input. Speaking of kids, whatever is left after creditors are paid off are given to them at the age of 18 with absolutely no strings attached. Now, wills also go through the probate process. So someone will have to file a case and be able to manage your money if you're sick or injured and you're not able to do it yourself. They get to make the healthcare decisions for you if you can't communicate, and that person may have to qualify to post a bond and make premium bond payments. Now, as you can imagine, this process can be a huge and messy and expensive nightmare for the people you love, and it can result in conflict among those who handle things and make decisions on your behalf. So if anything about this concerns you, whether it's the time, whether it's the cost, whether the fact that probate is public record, and so all of your information will be aired in the public, whether it's a potential for conflict, mark on your worksheet, I need to avoid probate court. But if that's not bad enough, maybe the worst part is that your loved ones may not even know what you have, where you have it, or how to find it. Where do you do your banking? Where are your insurance policies held? What brokerage firms do you use? Do you have crypto assets? If so, how do you access it? Who would know where to find what you have and how to access it? Most people do not share this information, and when assets are missed after someone dies, that money goes to the government to a department called the Department of Unclaimed Property, or the DUP. In Texas alone, there are over $9 billion, with a B, $9 billion in the DUP. So asset loss is a real problem. So now if what I just said about your money going to the government concerns you, mark that on your worksheet. I did tell you it was going to be interactive. However, there's a way to avoid all of this. And you've probably heard about a revocable living trust. It offers a lot of flexibility and keeps your family out of court, out of conflict, saves some time and money for you and your loved ones. But that's if it's accompanied by a plan and a trusted advisor to guide you and the people you've chosen to handle everything with you and the people you love. Assets would go to your kids at the ages that you want, and they can be fully protected from taxes, from creditors, from former spouses, and from injury lawsuits. While it's not that hard to set up, it does require some paperwork and then needs to be updated on an ongoing basis. If it's set up just right and it's well maintained, it comes into play upon your incapacity and not just your death. It will keep your loved ones out of court, it will keep your loved ones out of conflict, and it will ensure that everyone knows just what to do if something happens to you. But here's the thing, even a revocable living trust isn't the answer alone. Not even with a will, not even with a healthcare directive, not even with a power of attorney. We've seen what happens when people create a plan, they take it home, they put it on the shelf, they put it the USB drive in their drawer, and they walk away and they never think about it again. That plan is destined to fail. By the time something happens, it's out of date, the assets are long gone, or they've changed hands, or they don't exist in the same form anymore. Your loved ones will not know what to do, and all they will have is a pile of expensive papers and no one to guide them. So how is the Molina firm, PLLC, Life and Legacy Plan different? Well, today there are many options for estate planning. In fact, we believe that you should be able to make a will for free, and so does the state of Texas. If you give us a call, we will gladly show you where on the state's website the will templates are, so you can fill out a will all by yourself for free. But what we found is that estate planning focused on documents isn't really what you want. What you really want is a plan that works when you need it. That ensures that you made the best legal decisions, the best financial decisions for your life, and will guide your loved ones after you're gone. And we have created a way to ensure you get just that. So we began by taking you through a 2-hour process to clarify what you have, what's in place, what you need, and how to choose the right plan for yourself and the people you love, most affordably, most effectively, and ensure that you have a plan that will actually work. As part of this plan, we support you with legal and financial clarity, wise decisions, and the support of a trusted advisor to get the right documentation of your life and your legacy with guidance. If anything I've said today has you thinking, would my assets end up lost to the government? What would my family have to go through to take care of my affairs? Will they be able to find what I have and know what to do? Or will they be lost and confused? What should I do? I want to support you. I want to support you by letting you know that you've done the right thing. And we do that through the Family Wealth Planning session. Before I give you your next steps, I do want to address one thing, which is why you may not want a plan. Now, most people think that estate planning is only about the money. And while that may be true for estate planning, it is not true for life and legacy planning. Life and legacy planning is about your life choices. It's about your children. It's about your assets. It's about the people you love. It's about how much control you want over what happens and the kind of care that you want for yourself. Some married people think that they don't need a plan because their spouse is going to get everything anyway and they're going to be able to make the decisions on their behalf if they become incapacitated. But I'm going to tell you right now that that is not necessarily true. Your spouse may not, quote unquote, get everything. It depends on what kind of assets you have and how they're owned. Here's an example. A woman came to see another colleague of mine because she realized after her husband's death that she did not own the house that they owned together outright. They owned it jointly while he was alive, but once he died, without a plan, because he mistakenly thought she'd get all of his stuff, she owned the house jointly with their 2 children. And she couldn't sell the house without their consent. Her daughter would not give her consent, and so the little old lady was facing foreclosure because she couldn't afford to keep up that big house all on her own. Now finally, people think that they can't afford to pay an attorney for estate planning. The truth here is that if you don't have a plan, your family will bear the cost. And if you think that's expensive for you, imagine how time-consuming and costly it will be for them. Now remember, we went through the scenarios of what would happen if you passed away without a plan. Your children or the people you love are going to be combing over all of your house, all of your assets, to find your assets, to find your bank accounts, to find where you put your IRA, to find where you put your insurance policies, to find where you put your crypto, the codes for all of these things. They're going to be doing this in the process of probate no matter what. So if you really think you can't afford to pay for estate planning, just remember that generally speaking, not putting a plan in place will cost you way more than working with us to handle it for you today. So what's next? Well, I have hosted this short presentation to make it easy for you to get the right plan in place for yourself and the people you love. And now I'm going to make it even easier because all of my systems and processes are designed to help you do the right thing and make it as easy as possible to keep moving forward, even if you want to procrastinate. Put it off or not do it at all because it's just another thing on your to-do list. So in service to that, and if you've heard enough and you're ready to take the next step, I'm giving you a $1,000 golden ticket to support you. This $1,000 golden ticket gets you $1,000 in legal services as my gift, as long as you are willing to do your part by making it as easy as possible for me to support you. So on the screen in front of you, what you're going to see is a link to our firm's calendar. And what that's going to do is going to allow you to make an appointment with me to have a free 15-minute phone call so we can go a little bit more in depth about your personal needs and how we can address them. To get the $1,000 in legal services, which is the Family Wealth Planning session at no charge, plus $250 towards your legal planning after the Family Wealth Planning session, all you have to do is to commit to completing a little bit of homework prior to the first meeting and submitting that homework ahead of our 2-hour working session, during which I'll get to know you, your family dynamics and assets, and you'll get to know me and how the law will apply to your legal and financial reality. To get that started, come speak with me on your way out and I'll send you the homework. And if you need help completing it, we will get you that help. The great part about this homework is that it'll get you more financially organized than you've ever been before, so that no matter what, your loved ones will know what you have and where to find it if something happens to you. And for those of you who are watching online, we have set up the homework on the website. So you should be able to find that, and you should be able to complete it and send it back to us. So whether you're online or you're here in person today, you'll turn in your homework to me, we'll have our session, and together we'll choose the best, most affordable plan for you and the people you love. Now, the number one reason plans fail is because people procrastinate. And I'm giving you today a $250 incentive to not procrastinate any longer, because I know it's something you want to do for your family anyway. You know how I know? Because you took the time to be here with me today. If you do decide to wait and do this later, I will honor the free family wealth planning session, but call us, because I don't know that we're going to be in a position, just based on demand, to be able to honor the $250 discount towards future plans. So let's have that conversation. Give us a call at the office, and we can discuss that more. Now, finally, a heads up. You'll see that when you book the family wealth planning session, we're going to ask you for your credit card information, but this is only to hold your spot and confirm your commitment to submitting your homework before a session. Your credit card will not be charged. Your credit card will not be charged unless you do not submit your homework or you stand me up. Now, I set aside 2 hours to have this meeting with you, and so I can only accommodate a handful of sessions each month. So if you don't submit your homework, you're welcome to pay the $750 for the session, and we'll sit there and we'll do the homework together. Or if you stand me up, your card will be charged the $750 fee, because that spot could have been used for someone else. So to summarize, your next steps are: number one, complete and submit your family wealth needs inventory, whether it's here in person or whether it's online, and claim your golden ticket today. That will get you $1,000 worth of free legal services with me. If you need more clarification, or you still aren't sure whether you should pursue a 2-hour working session with me to review your assets, to review your family dynamics, to review the law, determine what will happen if you become incapacitated or when you die, you are free to schedule that 15-minute conversation, and we can discuss more by going to themolinafirm.com, by following us on social media. We have all of our information there. Or you can just simply call my office and you can make an appointment. Thank you so much for taking the time to make wise legal and financial decisions for yourself and the people you love. I look forward to meeting you and supporting you in making informed, empowered decisions for yourself and your loved ones.